And Valerie, do you want to start? I think our rush of people is coming in has kind of slowed down.
Okay, great. Well, thank you all so much for taking time out of your Friday afternoon. I'm sure that you all have better things to do, but I really appreciate your interest in this project and willingness to participate. This is a project that I think we've talked about for a number of years, and that was actually approved as part of, prior to the pandemic. But then, during the pandemic sort of fell by the wayside. And we've had a lot of discussions on the full commission about moving forward with this and who makes sense to participate in this. Um, I don't know if you've had a chance to look at the act itself. We're going to go over sort of the genesis of it, as well as additional information about sort of where the Uniform Law Commission was coming with this draft. But from my perspective, and I think from the perspective of a lot of the commissioners, this is something that's a pretty light lift as far as a legislative project, but that is very important for access to justice issues. And so, I appreciate your time today, and I will turn it over to Amy, who can talk about who is here and sort of where we're going.
Sorry, I'm continuing to let people in. Hi, everyone. I'm Amy Zebko. If we haven't met yet, I'm the director of the Oregon Law Commission. Valerie is the chair of the commission and is also the chair of this work group. And I thought one of the first things we could do today was just go through and do an introduction. Tell us your name, maybe geographic region, and your kind of your practice area or your area of interest. And Valerie, do you want me to go through and does that work for you?
Yeah, I think it works best if you call on people.
Okay.
I'll shortcut this a little bit by introducing myself. So I'm Valerie Sasaki. I'm a practitioner in Portland, and my practice centers around tax, but involves business issues as well as estate planning issues. And the estate administration is one of the areas where we see this issue arise quite frequently. So, or has the potential to arise. So that's why I'm interested in being here. Amy?
I'm Amy Zebko, as I said. I'm the director of the Law Commission. I'm going to call on Susan Gary next.
Hi, I'm Susan Gary. I'm a retired member of the University of Oregon Law faculty, where I used to teach trust and estates, nonprofits, and estate planning. And I've been interested in this project for a long time. I learned about it through the ABA early on and thought it would be great to bring to Oregon. So I'm excited that we're finally doing that.
Thanks, Susan. Robert, I was going to call on you next.
Sure, Robert Mauger. I'm a drafter with the Legislative Council, so I do the drafting for the bills introduced to the legislature for real estate, land use, landlord tenant, and a few other scattered areas of laws, and we'll be helping with when this becomes a bill draft.
Thanks, Robert. Jane?
Hi, I'm Jane Sternicki. I'm a legislative staff attorney with the Uniform Law Commission. I work on all of our real property acts, but specifically the Uniform Partition of Heirs Property Act.
Thanks. Ashley?
Hi, I'm Ashley Krolenbrock. I'm a solo practice attorney. My office is in Milwaukee, but I have clients everywhere all over the state. So I do elder law, so some estate planning and administration, guardianships and conservatorships, and Medicaid eligibility and special needs trusts are my big buckets of practice.
Thanks. Jeremy?
Hi, everyone. Jeremy Rogers. I'm the General Counsel and Government Affairs Director for the Oregon Realtors. We're a trade association of about 18,000 real estate professionals in Oregon. And this has been a major priority for our national organization, the National Association of Realtors, and several of our partner states across the U.S. who've implemented this, and looking forward to assisting. Thanks.
Thanks, Jeremy. Tony?
I am Tony Cullen. I'm an attorney at Farley Waterwit in Portland. I do mostly creditors' rights work, so represent a lot of lenders in real estate secured transactions. Also occasionally represent parties in partitions. I'm in two of them right now, and so kind of see both sides of it. Also, I'm the chair of the Debtor Creditor Legislative Committee for the bar section, and so I was involved in the last ULC bill that was passed in Oregon, the Chapter 12 of the UCC, and along with Mark Comstock and some others as well. So familiar with the process and happy to be here to join this committee.
Thanks, Tony. Andrea?
Good afternoon. I'm Andrea Meyer, Director of Government Relations at AARP Oregon. I was a lawyer a long time ago and resigned in good standing. Whether it's an A or B, I never remember, but it's a good one. And AARP has over 500,000 members here in Oregon. We advocate for the 50 plus and their families, and this is one of our issues. We're a nationwide organization and work on this nationally and nationwide as the importance as it affects older Oregonians. And happy to be here.
Thanks, Andrea. Mark?
Hi there, I'm Mark Comstock. Been practicing in the Salem as my base, but all over Oregon for 40 plus years. I generally a commercial litigator kind of practice that touches real estate, creditors' rights, and everything in between.
Thanks, Mark. Mark was also a OLC commissioner for many, many years, so he knows how everything works. Gabe.
Hi, I'm Gabe Hansen. I'm 2L at the University of Oregon, and I'm a research assistant with the Oregon Law Commission.
Thanks, Gabe. Tabitha?
Hi, I'm Tabitha. I am state underwriting counsel for the Fidelity National Title Group. We do title insurance, so we're very interested in this sort of stuff. We need to be able to determine what's necessary to ensure the sale after the partition. So I'm glad to be here.
Thank you. Shanna?
Hi there, I'm Shanna Newell. I have a little note here that my internet is a little unstable, so I hope you can hear me, and we'll proceed with that. Shanna Newell with OJD in the Office of Government Relations.
Thanks, Shanna. Justice Walters?
Hi, Martha Walters. I'm a Uniform Laws Commissioner, and I was president of the ULC at the time that this act was first drafted, and I'm very excited to see Oregon taking a look at it.
Thank you. Shane.
Shane Antolds. I'm an attorney at Horniker Cowling in Medford. Focus on estate planning, probate, trust administration, do a lot of transactional work too.
Thanks, Shane. Justice?
Thank you. Justice Raji, Director, Advocacy and Civic Engagement for the Urban League of Oregon. Over 80 years serving Oregon in a civil rights and also programmatic services capacity. And Justice is just my name, not Justice the title. Just thank you for giving that out the way. I didn't want any confusion, especially in the room for legal practitioners. And I'm here, heirs and these issues are very significant to our community and those that we serve. So I'm here to represent in that capacity. Thank you.
Thanks. Tess?
Hi, everyone. Tess Milio. I am the contract lobbyist for the Oregon Association of County Clerks. So I'm not a lawyer. I will just put that out there. And there are, 36 counties. They're all a little different, but generally the county clerks are elected officials and tend to work on both the elections and running our elections, but then also recording documents. So I think that's kind of our overlap here. So looking forward to learning more from you all.
Thanks, Tess. And Valerie, that's it for our introductions. We have 17 people here today.
Great, thank you so much. So Amy, did you want to do the overview of the process, or do you want me to?
Why don't you go ahead and I can throw things in if
feel free to interrupt, Mark. Justice Walters, feel free to interrupt either people on this call who are much more experienced than I am, Professor Gary. So the process that we typically will do as a work group is to look at the model law and the Model Act the Uniform Law Commission has promulgated. And often there's commentary associated with that. The OLC has a great webpage. I think we sent a link to the webpage for downloading, and then I think Amy sent the Model Act around earlier today. So what we do as a work group is we look at the language of the Model Act. And there are two ways to do this. We've done it both ways. You can either start with the existing law or start with the Model Act. And I think in this case, it probably makes sense to start with the Model Act. And go through section by section, deciding if this makes sense for Oregon. What the individual experiences that we bring to the table are that inform, how we interpret this, how for those of us with clients, it's likely to have an impact on our clients and our practices, and then talk through these issues. Because the best part of the work group process is that we're not all going to agree. And we're not all going to agree about everything. We're not all going to agree maybe about anything, at least to start with. But it's an opportunity for us to really listen to each other and work through challenges that may come up as we're working with the legislature on this. So we're very lucky to have Legislative Council with us today. We're not always so fortunate to have Legislative Council sit in on these meetings. So I appreciate your attendance, Robert. And, so once we figure out, okay, is this language good for Oregon? How does it fit within the context of our current statutes? Then it will be Robert's task to take our recommendations, the model language, and put together an actual draft of language for the legislature to consider. And so I don't expect that this process will take the 5 years that it took to do the LLC Act. That was a much longer bill. But I think we'll talk about meetings, and that's on the schedule here coming up. Are there any questions about the work group process? The other thing that I did want to say is if there, having heard where everybody's coming from, if there are folks that you believe we should bring to the table and have involved in these discussions, please let us know. I think we're very fortunate to have the group that we do, but there very well may be other folks who have thoughts on this that would be a value add for us to consider as we're working through the language. So please don't hesitate to let Amy know, let me know, and we'll try and reach out to those folks and loop them in. We also may, at some point down the road, have folks who are interested parties who may just come and join our work group sessions to observe. And that can be really useful as well. So if there are folks who, either from your own organizations or from other organizations, that you think it would be valuable for them to come to specific discussions, I would encourage you to work with Amy to make that happen as well, because she keeps a list of folks who will be looped in. So we want to make sure that this is as broad a process, as inclusive a process, and as deliberate a process as we can, while still being respectful and acknowledging that we may not always agree on what the answers look like and what the language should be. One thing I have to say for the lawyers in the room is that we will come up with what we think the best language is. But then it will go to Robert, and Robert has the unenviable task of making it fit within the context of the Oregon Revised Statutes. So it can be very hard for lawyers who fall in love with the beautiful words that we write to hand them over to another person who has to make them fit with the context and format of the statutes. So we're going to be focusing principally on what the words mean. But if there is specific wording, verbiage that we need to have in it to make the law as effective as possible, we also need to be able to flag that for Robert. Amy?
I was going to ask Professor Gary to talk briefly about the reporter's role and the report that comes out of the Oregon Law Commission. Would you be willing to do that?
Sure. Yes, I'm going to be serving as the reporter for this act, and in that role, I'm going to keep track of comments as we go through our discussions. There will be sometimes in the discussions where something will be flagged to say, we should make sure the report includes a description. The report that we will produce, and that will be circulated to the work group. I value input from everybody in making that before that becomes final. That report then goes to the Oregon Law Commission, because this is a bill, when we're finished, that will come out of the Oregon Law Commission, and they will approve it before it goes to the legislature. So the report will explain to them why we're doing what we're doing, any nuances about how it will be applied or what particular provisions mean. And then when it goes to the legislature, the reports are typically introduced as legislative history in the committee meeting when there is a hearing on the bill. So it ends up being part of the legislative history. So as we go along, I will create drafts that I can share with all of you and get feedback, and we can kind of fine tune as we go.
Thank you very much, Professor Gary. And I also wanted to flag that these meetings that we're having are open to the public and subject to various governmental meeting rules. So, these recordings will be preserved so that if folks have questions later down the road, okay, when they looked at this section, what were they talking about? They can actually go back and look at it, the meeting. But the thing that the legislature actually considers when it's approving or disapproving of the bill proposal is going to be the report and any testimony that we bring to the legislature.
And then I wanted to just touch on a couple of logistical things so that you guys had a kind of idea of what we're going to be making sure that you have on a timely basis. So Gabe and I will be putting together meeting notes, not minutes, but meeting notes after every meeting. So we will keep a written kind of record of the big picture conversation pieces. And this is just a quick reminder for you if you're like, oh, when did we talk about issue X? Well, we talked about it in November of 2025. And so you'll have those available and those will go out. We'll be sending out meeting materials, agendas, any documents that Valerie and Susan feel are appropriate and necessary for the conversation. And if there is a particular issue in a section 7 of the bill or the act that you as either a practitioner or a representative of an organization feel strongly about and want to write something about, we can share that too. So we're meeting once a month. If there's something you want to talk about, please come and get that information to me so we can set it up in a way that the conversation can be productive. As I said, we do meetings once a month, excuse me. And that might change if we hit a snag in our scheduling, which we can talk about in the end. Like if we're like, oh, it's July or August of 2026 and we need to get stuff done, we might meet more often. So that does happen on occasion with some work groups, but like Valerie said, this is not the LLC Act or the Municipal and Justice Courts Act. This is significantly shorter, so I'm hoping that won't happen. And then Gabe and I are here to make your lives easier. You guys are the certified smart people. You guys know this subject area much better than we do, but we're here to, if you have questions, if you want to suggest that we reach out to somebody, we're here to make this an easy process for you guys. So please let us know how we can help.
And I will, as the person who will be chairing most of these meetings, I will just tell you that I detest meetings for the sake of meetings. So we're going to try and keep them as efficient as possible. And if we end early, we end early. So, we're not, I want to make sure we have enough time to be deliberate and thoughtful, but I don't want to waste your time. I know your time is valuable. All right. So I think, do we want to turn it over to Jane?
There you are, Jane. Sorry, you're moved on my screen. Jane, I've set it up so you can share your screen. I know you had a
Perfect.
PowerPoint that you wanted to share.
I sure do. Thank you so much.
Of course.
All right. Can everyone now see my PowerPoint? Great. Okay, so I'm going to give everyone just a brief overview of the Uniform Law Commission's Uniform Partition of Heirs Property Act. This is going to serve as the basis of our draft, but I'll get into a little bit more of the specifics of the act and kind of the non-negotiables from a uniformity perspective, and then the areas where we may have some wiggle room. So as background, let's see, can I advance this slide? Yes, I can. Okay, perfect. So the UPHPA was drafted by the Uniform Law Commission. If you're not familiar with our work, we are a nonprofit state-supported organization. We create uniform legislation in the areas of the law where it makes sense. The UPHPA has been available to the states for enactment since 2009, and that was after a 3-year study and drafting period, which is pretty common for our work. It has been enacted in 26 states and territories. The ULC supports all 50 states, Puerto Rico, the Virgin Islands, and DC. So it's 26 states in ULC counting, which is a little different than the normal 50. So here's our map of all the states where it's been enacted. So you can see pretty good numbers in all of the states around Oregon. I would say the only region where we've struggled is sort of the Midwest, upper Midwest area. And I think the issue there is demonstrating that this is a problem. But I think we've seen, at least anecdotally, and there's obviously interest in bringing this act in Oregon. So we are accepting that this is, at least a common enough problem to begin to address. So the way an issue with heirs property comes about is that property is passed down through the generations by someone who either died without a will or with just a very simple estate plan. And that can often result in dozens of heirs owning as tenants in common. And for us lawyers, we can go back to our real property class days and remember that tenancy in common has the property owners owning just one small percentage of every single square inch of that property. So instead of me owning the western acre of my property and my cousin owning the eastern acres of my property, everyone owns this tiny little fragment. And that makes it very, very difficult to do day-to-day maintenance on the property. They can often experience issues with falling into disrepair because it's so difficult to administer this property. And I want to note that the Partition of Heirs Property Act addresses a major concern, which is that owners of heirs property are vulnerable to forced sales. But we often say that this act is not a silver bullet. It does not address absolutely everything that comes up with tenancy in common, like all of the issues that come up with tenancy in common as an ownership structure, but we do our best to address this one very significant problem. So that significant problem is forced sales. Heirs property is at risk of being sold in a forced sale for pennies on the dollar when just one co-tenant files for partition. So the UPHPA does not disrupt that. All of the co-tenants still have a right to file for partition, and partition is telling the court and the other co-tenants that they want out. The issue is that often that property ends up being sold on the courthouse step for pennies on the dollar because of existing partition procedures that do not give adequate protection to the remaining heirs who do not want out of the property. So that process deprives these heirs property owners both of their ancestral home, and to add insult to injury, it deprives them of the generational wealth that is associated with that property. Similarly, one of the common vectors for this type of predatory partition action is a property developer who wants to acquire the entire parcel. This is especially common in the South. There are many parcels of land that was owned by Black Americans that was lost when a property developer identified just one heir, and often it would be the heir who was the farthest removed from the property, or who maybe was the one who needed cash the most, and they would buy out that share and then force a partition action and kick everyone off the land. So the UPHPA does still preserve that right to file for partition, but it creates a series of due process protections that are designed to first keep families in their homes, keep the land working if it's a working farm, whenever possible. If that is not possible, then it ensures that the family receives at least fair market value for the property if it has to be sold. So those are the two broad goals of the act. Now I'm going to get into what we consider to be the pillars of the UPHPA. So these are the concrete aspects of the act that we need in order for the act to be uniform. And I can certainly distribute like a paper copy of this as well, because this is what we view as the backstop when we're considering the work of this group. So
can I interrupt briefly? Would you consider sending your slides to Susan after the meeting?
I would be more than happy to, absolutely.
That would be great. Thanks so much.
So the first pillar is that the court has to determine whether the property qualifies as heirs property. And I will put a slight asterisk on this one. In 4 states and territories, California, DC, Virginia, and Maryland, they expanded the UPHPA to apply to all partition actions. And we do still consider that to be a uniform enactment. But if the act is not expanded, then we do need this court determination of whether the property qualifies as heirs property. Generally, that means that just 20% of the co-tenants who own the property must be related. But there are a couple other criteria that are just very slightly more complicated. And if the property does qualify as heirs property, then we need to follow those due process protection steps that are created by the Partition of Heirs Property Act. So that's pillar 1. Pillar 2 has enhanced notice provisions, which include notice by posting at the property when the plaintiff has requested notice by publication. So notice by posting means that there's like a conspicuous sign outside the property. And the purpose of that is that we want to make sure that the heirs, who are sometimes not necessarily the easiest to find, we want to make sure that they're able to be found through voice through the community. So we want to make sure that they can be notified by other people in the community driving past that property and saying, hey, I think I know of a cousin who lives in Alaska who's affiliated with this property. There's also an option for notice by other more conventional means. The third pillar is that if commissioners are appointed to administer the sale, they must be disinterested parties. That's a key aspect. It cannot be someone who's affiliated with either side. The fourth pillar is that the property must be independently appraised, assuming sole ownership of a fee simple estate, unless all of the co-tenants agree to another method. So if they happen to recently appraise the property, they don't need to go through the expense of doing another appraisal. But the appraisal is a very important step. It makes sure that we know what the fair market value of the property is, which is relevant for several additional steps that I'm going to get to on the next slide. So that appraisal is kind of our backbone of the valuation throughout the process. So next is one-way buyout provision. So this is something of a right of first refusal. So the way this works is that the co-tenants who want to stay on the property are given the opportunity very early on in the process, as soon as notice and the appraisal are done. The co-tenants who wish to remain are given the opportunity to buy out the share of the co-tenant who filed for partition, the one who wants to leave. This is a very important step because in many cases, the action would end here. The co-tenants who want to stay buy out that share. We are done with this partition action quickly, and everyone is able to move on. The family stays on the property. This also has a very important quality of shark repellent, as we call it, which is that this makes it somewhat unattractive for a property developer to buy out that share, because they may end up going through all of this litigation to just have their share bought back from them by the co-tenants who wish to stay. And again, that buyout, it's at fair market value. So let's say one of the co-tenants owns 10%, the property is valued at $1 million, that 10% is going to be $100,000. Notably, also the co-tenants who wish to stay have time to secure financing. So if let's say 2 of the co-tenants want to buy out that $100,000 share, but they do not have liquid funds to do so, they are able to arrange financing, and that timeline needs to be preserved within the act. The second to last pillar is an enhanced preference for partition in kind with consideration of non-economic factors. So many courts do consider partition in kind when they're determining whether to either physically, partition in kind is physical partition. So when they're determining whether to physically partition the kind or sell it, partition in kind or sell the property. But a lot of courts blow past partition in kind. They just say, for example, let's say we have a farm with a house on it. Many courts would say, well, because there's a house on it, it's going to be very difficult to figure out how to divide this property up. We're going to not bother. We're going to go directly to sale. Under the UPHPA, the court has to go through several factors before determining that partition in kind is not possible. And in the scenario with the farm with a house on it, maybe one of the co-tenants gets just the house with no land around it. We wouldn't have a landlocked parcel, but they get just the house with no land around it, and another co-tenant gets a larger piece of land to offset the cost of the house. The purpose of partition in kind is to make parcels that are of equal value, not necessarily of equal size. The final pillar of the UPHPA is that an open market listing has to be the default, and only if it would be economically advantageous to the co-tenants, so the co-tenants would get more money from it, can the court authorize another sale through a different mechanism. But generally, we find that an open market listing is going to be the most effective. I was recently in a meeting where someone said that you would never list your house for auction if you wanted to get the most money for it. So open market sale is the default here, unless it's very clear that something else would be more advantageous. So I want to go over just some very common state level modifications that have been made that are still within those pillars. So this is like maybe a jumping off point of some places where we would have a little bit more flexibility. So in New York, there's a mandatory settlement conference that occurs, I think, after the notice and appraisal stages, where the parties all come together and see if it's possible to settle. We still consider that to be a uniform enactment, just like all of these others. In New Jersey, we spent significant time working with their administrative office of the courts to add in a special master to administer the partition actions. That was in line with other types of property actions in New Jersey, so we just wanted to conform with their existing procedures. And to the extent that Oregon does have something where there's an existing court procedure that we need to conform to, we will absolutely take the time to do that. In Illinois, there's an equitable fee shifting provision that factors in the parties' good faith negotiation. So if a party did not act in good faith before they filed the partition action, they may be more likely to have to pay the attorney's fees in that case. And then, as I mentioned, California, DC, Virginia, and Maryland have all expanded the Partition of Heirs Property Act to apply to all partition actions. They figured that they were taking one bite at the apple. They might as well not create two different tracks for partition. They just decided if you're filing for partition, you're going to get all of these additional due process protections, whether you are related co-tenants or not. I think, the last thing I want to touch on is just the Farm Bill. So in 2018, the federal Farm Bill, we had an example of cooperative federalism here when they created incentive for states to enact the UPHPA. So there's a loan program for heirs property owners to go through the process of clearing title, which is another aspect of one of the many things that can result from heirs property ownership is that title is not clear. It's not clear exactly who owns the property and in what shares. And there's a preference under this loan program for lenders in states that have already enacted the UPHPA. Additionally, property owners of heirs property in states that have enacted will be eligible for a farm number if they have begun the process of clearing title. A farm number is very important. It allows them to be eligible for disaster assistance. So when they have begun that process, then they can be eligible for a farm number. And finally, clearing title, anything that we can do to help encourage people to clear title does address some of the other issues associated with heirs property ownership. It can help them avoid predatory actions, make it easier to get financing, make it easier to improve the property. So anything that gets people closer to clearing title is obviously quite important to us. So that's the contents of my PowerPoint. I'm more than happy to share this with you all to review later, and I will send out like a finalized copy of those pillars as well.
Thank you so much, Jane, for that overview. And I'm sure we'll have questions as we move through this process, and we'll look forward to picking your brain about those. One question I did have for you, because I think Washington was one of the states that you had on that chart. Were there any significant deviations from the model language in Washington, such that, similar to what California and DC and Virginia did?
There were not. As far as I know, Washington has pretty close to a perfectly clean version of our act.
Great, thank you. Does anybody else have questions for Jane? All right, well, if you're like me, something will occur to you in about 20 minutes. So, we're keeping this line of communication open. We're very lucky to be able to work with Jane. We're very lucky to have Justice Walters with us, who was involved in when the original act was put together.
And I'm going to put my email address in the chat box just in case anyone has anything at the stroke of midnight that they must ask.
Great, thank you. And I imagine Amy and Gabe will put that in the notes. Okay. So I think the purpose of this meeting was, from my perspective, really to just do an introduction to the act. See if folks have any questions about it. Now that you have the hard copy of the bill, I know I'm going to sit down, and I've got a couple long flights coming up here in the next week, and take it with me. And I'm sure things will occur to you as you go through this, but we wanted to make sure that we took the time to allow everybody to meet each other, to have this overview of the bill before you really sit down and go through the wording of it. And then at the next meeting, what I would expect is that I or someone else will propose an attack methodology to go through it. And it probably will just involve starting at the beginning and going through. And if you have thoughts about what would be most efficient from your perspective, let me know too, or let Amy know, or let Professor Gary know. And I think that's it, is other than scheduling. Amy, was there anything else that you wanted to go over?
So actually, I have two things.
Okay.
The first is pretty straightforward. One of the things that we do at the end of this whole process is, as Susan mentioned, Professor Gary mentioned, is we do a report. And we will list you all in that final report. What I would like to do is make sure that there is a roster with your name and organization posted on the Commission's website on the Partitions of Heirs property page, just so if anyone is curious and wants to reach out, they know that you all are participating in this work group, and put your names out there. Your email addresses will not be out on that list. So I'm going to send that list out to you, probably not this afternoon, but early on Monday. And if you have any changes to it, or if, God forbid, I've misspelled your name, please let me know. And that final roster will be posted when we post the agenda for the next meeting. And so that we will have that just publicly available for folks.
I want to reiterate there too, if there are other folks who should be participating, please, let's get them involved early in the process, because we really want to make sure that we have the opportunity to have those meaningful discussions before we send the language to Robert to get a bill draft.
Exactly. And then the other thing I wanted to check in about was that this is a 2027, the goal here is a 2027 bill. And the commission, because we have this report process, we have, there's the drafting deadlines for those of you who do a lot of legislative stuff. The commission's goal is always to pre-session file bills. So that would be a December 2026 pre-session filing. We have a note, I believe it's an early December 2026 meeting scheduled for the commission to approve or not approve. Like, commission can always say, hey, this isn't our bag. To approve the draft and the report. So really we have to wrap up and complete everything by the end of August of 2026. And what we're looking at right now is a monthly meeting between now and 2026. I know about half of you are probably somewhat or very involved in the legislative session. So February's something we can talk about, but I wanted to flag for you potential days that we might meet. And so we were looking at Tuesday afternoons, Thursday afternoons, and Friday afternoons. And if anyone has like, oh, the second Tuesday of the month is terrible for me, or the third Thursday of the month is perfect, that sort of thing, please let me know go ahead. Someone just said something.
No, I just coughed, sorry.
Oh, okay. So I'll send an email about this out on Monday to figure out what our monthly meeting is will be going forward. I would like to suggest that we have a November meeting on the 13th, which is a Thursday, at 2 o'clock. And I will put that in the email as well. And we will see if that works. And then we can also figure out if Thursday is not the perfect day for everyone, we can figure it out and confirm it at the next meeting, and we can set that up permanently. And then I will send out calendar invites for the next several months to just put that information on the calendar. Valerie, is there anything?
Yeah,
Oh, I
think
will
Andrea-
mention.
I think Andrea
Oh,
had
go ahead.
a question.
I was just to say, my memory of the 24 session is so long, but a shorter session is a different beast, but Friday afternoons might be the safest bet if you want to try to convene us throughout the cycle. But again, it might be Monday through Friday, but it usually is the one area.
Yeah.
One day.
And I think February is an interesting, and I haven't had a chance to talk to Robert, and I know he's probably going to be very busy. So we will perhaps Thursday, the February meeting, we will figure that out. Either we won't have a meeting in February, or we will schedule that one however we want to do it. But I do want to give people the opportunity to say, looking at the whole 10 months or so that we have, this is what works best over 10 months, and don't let the legislative schedule dictate our entire schedule, even though it will.
I will say too that, you know, the whole bill is only about 20 pages long, or the whole model act is only about 20 pages long. So my expectation is that we will probably finish this towards the early side of next summer. And then have some time to fine tune the report and other things, and start having conversations with legislators. Although, as we discovered this year, summer can be a little bit, the lawyers are out of the office at the different time than the legislature is out of the office, as we discovered. But, you know, I think we tend to do better when we lay our groundwork with folks. And so we want to make sure that we have enough time to do that as well.
So unless I hear from somebody right now that November 13th is secretly somebody's birthday party and we're all invited, I might stick with November 13th at 2 p.m. And I will send that calendar invite out on Monday. And then I will also send out additional information that we've talked about. And I will also reach out. Thank you to those folks, Tess and Andrea, you both did. Thank you so much for giving me additional names to reach out to. I'll check in with those folks as well. And if anyone else has any suggestions, please let me know. And I'm happy to do that outreach just to get people here.
Yeah, and I will say too that one of the things that I think about when I think about the impact of this is that I think there's going to be a real positive impact on some of our minority communities that have been historically disadvantaged by some of these processes. So to the extent that there are other folks within the minority communities that we want to ensure have a voice at the table, we really do want to invite those folks too. So, and that's, I guess, the last thing that I have to say, but thank you all so much for your time. I know your time is valuable and everybody's busy, but I appreciate your taking the time this afternoon.
That's it.
Thank you, Tessa. Yeah. Oh, yeah. Hi, Tony.
Sorry, I just want to ask a quick question, and sorry, I had to go off for just a second, so I hope this wasn't covered, but wanted to ask about, Jane, you shared earlier the examples of those states that had some variance in their adoption. Is that to suggest that the others didn't have variance? And I guess to get to the point of my question, Washington's probably the state that most of us who might have seen this before have experienced it in, and so wondering if there's any sort of chart that would compare how they adopted versus what we have.
Yeah, that was Valerie's question as well, but I'm more than happy to answer it again, which is, as far as I know, Washington had a very clean enactment of the UPHPA. So I don't think there were significant deviations. You're right, though, that those are the states that have the most significant changes, and the vast majority are, like, you know, clean with the exception of very minor changes for existing court procedures or something similar to that. Really, the purpose of showing the other states that have made those somewhat significant changes is to just demonstrate the areas where we may have a little flexibility if there are stakeholders or other folks who want to modify in line with existing precedent.
Thanks. Sorry to make you repeat.
No, of course.
All right. Anything else for the good of the order? Seeing none, I'm going to give you back another 15 minutes. Have a great afternoon. Really appreciate you all.
Thank you.
Thanks all.